Welcome to our group homes class today. Really excited about this one. The topic for this class came about when I was interviewing Greg Bloomberg over at the City of Scottsdale Code Enforcement. And he's been around for a very, very long time, 31 plus years. He helped actually draft the statutes involved with these facilities. And he brought some really important points out that not only do managers not aware of, but a lot of attorneys aren't aware of either. I know I walked away from that class learning 2 or 3 different things in sitting down and talking with him. So it was really informative, and you hear a lot of this all the time. Can you enforce a group home care facility? We sometimes say no, hands off. But actually, there are many times when you can enforce and resolve issues. But the key to doing so comes down to understanding what the difference is between these two. So before I get into the meat of it, I wanted to do a dumb law. I always start with picking on at least one state. What state should we pick on with dumb laws today? Andrea, where were you born?
Arizona, that's boring.
That is boring.
Kentucky.
Kentucky. I have not done Kentucky.
Yeah,
Let's do Kentucky. That sounds good.
Because that's where the US UPS hub is, and my iPhone sat there forever.
Yes.
So they already saw.
Well, then that's good. We want to pick on Kentucky then.
Pick on them.
Your new iPhone?
I did.
All right. This is a good one. Throwing eggs at a public speaker could result in up to 1 year in prison.
That's awesome.
It says it was repealed in 1975, though. So apparently it's okay now to throw eggs at a public speaker. Let's see. I'm going to pass that one.
Oh, more extras.
Good morning or afternoon. In Owensboro County, a woman may not buy a hat without her husband's permission. These are dumb laws in Kentucky.
What's
By the way,
wrong
you
with that
missed the
law?
first one. Throwing eggs
there?
at a public speaker could result in up to 1 year in prison. All right, so let's get into this. First thing is, how many of you are aware of the process to get a license to operate a care facility in Arizona? None of you have ever tried to do it or seen it work? So in the podcast that I had with Greg, we talked, you don't have to turn to it, but it is in your materials if you want to look at it later. It's right roughly in the middle. Basically, this is how the process goes. I'm going to read parts of it because this is straight from what Greg said. If someone wants to operate an actual licensed care home in Scottsdale, and by the way, it's very similar, if not identical, in other cities. There are some changes in different cities, but because the process goes back to and the actual license lies on the state, the process is basically the same. So if I want to operate a care facility in Scottsdale, the first thing I need to be aware of is I can only have up to 10 residents. So if you have a care facility with more than 10 residents in your condominium or planned community, that's technically a violation, okay? So there is a maximum of 10 residents. They then submit an application. They have to get a certificate of occupancy with the Scottsdale before they can actually get a formal permit. So out of the blue, if I submit an application to Scottsdale, they'll just give me a certificate of occupancy. And they just issue that out of hat, and they give them a 6-month window. So this is what he says. So we have to go ahead and grant them a C of O permit so they can go out and get their occupancy established. There's a 6-month window basically where they have to present us with proof of licensure. If they don't come to us within approval, it's void. So they come in for their pre-app, and we establish what's called an adult care home case. It's an AC case. And we do a staff approval. They give us a floor plan and a site plan, and we do a quick approval for them and give them the permit so they can start the clock. And then they have to work with the state to get their actual license. So the very first things first, when they start the process, they have to get their certificate of occupancy. Scottsdale and other cities will give them a grace period to go to the state, get their license, and then they have to come back to the state with their license, or else they'll be revoked within 6 months. If they don't get a license, we're going to talk about what happens then. But before we do, this is probably the key in understanding what we're talking about today. So, what is a group home?
A
Yes, perfect. It's unrelated people living in the same home, whether it's in a condominium or planned community. What's a care facility then?
Where there's a supervised adult supervision, care supervision on site.
You read the materials this morning, didn't you?
Actually, it's several weeks ago.
Several weeks ago? All right. So this is the key. A group home isn't necessarily one where you have sober living facility, you have, it can be, but when it comes to the law, a group home's different than a care facility. So a halfway house where there's care and supervision, that's the key. If there's care and supervision, there has to be a license involved. And that's where we're gonna get into this case law. If there's no care and supervision, it's just a bunch of college roomies living together in a unit, it's a group home. And the interesting thing here is, right off the bat, you can prohibit group homes for a couple reasons. One, from a pure city code requirement, this is what Scottsdale says anyways, and I believe in my research, most cities have almost the exact same thing. In terms of our zoning ordinance, a group home is a home with 6 or more residents in it. So if you only have 5 people there, Scottsdale and the cities aren't gonna do anything about this. It's not considered and classified as a group home. But if you have 6 or more people living in that home that are unrelated and not a family, then you can. It's illegal for a group home to exist now, they changed this law by the way, now for a group home to exist in a single family zone area. Group homes are okay in a multifamily area as far as the city's concerned, but not in, if it's zoned city single family. This is exactly what he says. Quote, the catch is you cannot do a group home in a single family zoning. You can only do a group home in multifamily zoning now. That's a clarification in our ordinance, and we have had a lot of folks come to us wanting to do group homes in single family zoning, and you can't do that anymore because it's really not conducive to single family setting, okay? So in a lot of your communities, you're zoned what? Single family, yeah. And so if you have a group home, which again, take away that whole thought about halfway houses, rehabilitation centers, that is not a group home for purposes of today's class. If it's a group home with just a bunch of unrelated people living there, 6 or more, then, and if it's single family, they're not protected. And by the way, if they're not protected, oftentimes when it comes to the group home, you turn to your CC&Rs. So if you have rental, oftentimes we talk about this in the materials for about a page and a half. In the group home setting, a lot of times they're tenants, right? So you have to abide by what the state law says about rentals and what your CC&Rs say about rentals. So if your CC&Rs prohibit renting to, on a more, not a single family housing basis, so you're not renting just one single family, but if it prohibits renting in a group home scenario to multiple people for college students, whatever, you can enforce that. The case we're gonna go over had nothing to do with group homes where there is no care and supervision. It only went, the case was only concerning care facilities. Are there questions so far about that? Pretty clear, right? So now let's talk about care facilities. Are there different types of permits you have to have? Are there different types of classes of permits to operate a care facility? What do you think? A lot of people think there are. Like, if I'm gonna operate a sober living facility versus a elderly care facility, you'd think you'd be licensed differently, right? I'm gonna close this door.
You would think that.
This is what Greg says. There's just one standard care home permit. So what happens is, remember the process, the city, respective city gives a grace period to start the application, and they tell them to go to the state, Arizona Department of Health and Safety, to get their license issued. And then they come back and the Arizona Department of Health and Safety gives them one license. Okay? So, that's that. There's one type of license. when it comes to lodging complaints, there are a few things. So, if you call the city of Scottsdale, and how many of you have ever made a complaint about a group home or a care facility of the city? Whether it's Scottsdale or Fountain Hills, it doesn't matter. What happened?
Nothing. The city didn't get involved. It was with.
What did they tell you?
That they had their permit, it was up to the HOA to enforce.
Uh-huh. And what city was that?
Mesa.
Mesa? What was the fact behind it? What was happening?
It was foster kids. There were, eight foster teenage boys, and the kids are just unruly and causing a lot of issues.
Okay, so you have 8 foster kids that are out there making a lot of noise, probably picking fights in the common area, whatever. And you call Mesa and they say, we're not gonna do anything about it. How about, have you ever, who else has had a similar situation? Yeah.
It was Phoenix.
Phoenix? Okay, so what did Phoenix say?
Phoenix investigated it.
What was the facts that made Phoenix investigate it? Was it similar to Corinne's facts?
There was drug paraphernalia in and around that unit or that home
Uh-huh.
that we were finding. And there was reports of people coming and going from that unit. People were saying that there was drug activity, so they actually did investigate it.
Perfect. What was the end result of that investigation?
They wouldn't say.
Did they refer it off to the department?
Mhm.
And what happened with the department? Did they yank the license?
I believe it, and they did
How long did it take?
a while.
Yeah, it takes a while. It can take anywhere from fastest I've seen with the Department of Health and Safety is about 4 or 5 months, but I've seen it much longer than that. Yeah. So, anyone else have problems? So, basically, what we've, in this podcast with Scottsdale at least, so, and it's the similar process with most other cities is, if they do investigate and they find some reason to enforce their own codes, like nuisance, they'll pass it off to the police department to investigate code violations in that way. But if there's an issue with the permit itself, the license to operate the care facility, they don't have jurisdiction to revoke those licenses. So they send that off to the Arizona Department of Health and Safety. And here's your contact for the health and safety. It's in the, I don't know if it's in the materials, but probably not. I added this just this morning because I received this from Greg this morning. So here's the information, and I'll make sure to send this to you, or I can email it to all of you later on. But Nicole Morong is the state licensing team leader at the Arizona Department of Health Services. And here's her direct line, her fax number, her email, and where you can find her on the web, and her address in case you want to show up and do a face-to-face with her. I put Greg Bloomberg's info here as well, because yes, he's with Scottsdale, but for those of you that came a little late, he actually helped draft all the statutes related to care facilities. He's a wealth of knowledge. He's been with Scottsdale doing planning for 31 plus years, and he knows his stuff when it comes to group homes and care facilities, and what we can and cannot do. So, this is great. If you feel like there's a violation going on, Nicole can answer a lot of your questions, same with Greg, but just keep in mind that when it comes to these investigations, the city, if they do investigate, they're not gonna be able to revoke that license. It has to come from the state. The state is the enforcement body there. All right.
So is it even worth going to the city, just go right straight to the state?
I think it's worth going to the city because, remember, the state has their own set of requirements, but the city has their own code requirements.
Okay.
So if they do find a violation of, an ordinance violation, like, they may not be able to yank the license, but they can certainly determine whether there's a nuisance involved, whether there's, Regis mentioned drug paraphernalia. If, in Mesa, when I used to be a police officer in Mesa, there were a few times where I would get these calls where I'd have to go investigate a loud party complaint, and it was originating in an HOA. It was a complaint by a neighbor. I was going there as a cop to investigate the code ordinance to determine whether it was loud or not. Then I'd find beer or whatever, and I would make the arrest or do whatever based on city code and city laws. So yes, absolutely get the city involved. They do get flooded with a lot of these calls, so they have to pick and choose the ones that sound like ones they would actually step in on versus those that wouldn't. If you just listen to the fact comparison between what Regis explaining for inexplained, Regis has had drug paraphernalia, so there's a criminal element already involved right then and there. If you have somebody tossing cigarettes butts onto another person's property, or out on a balcony, second-story balcony condo, smoking a lot and tossing their butts down to the lower unit, that's a health and safety issue that may require involvement, not only police department, but fire department could come in. One example that Greg mentioned in a horror story was a lady called him about 10 people living in a condo. Now, is that a group home or a care facility? There's no care, there's no supervision, just 10 unrelated people living in a condo
Group
unit.
home.
Group home, right. That condo was zoned multifamily. So, can Scott, and this is in Scottsdale, so can Scottsdale do anything about that group home? From a hey, you're violating the zoning ordinance by having a group home here? No, why?
Because it's, group homes are allowed in multifamily.
Exactly. If it was zoned single family, sure. Because it's 6 or more is a violation. If it's zoned single family, can't do it. But because it was zoned multifamily, there's nothing that Scottsdale could do. But these people were smoking, they were loud, they were everything else. So they did send out the fire department to look at whether there was a health and safety issue there. And from what both Greg and I understood is the fire department took care of it and the problem resolved itself. Especially because they were smoking and throwing cigarette butts on landscaping, and not only that, but when you have that many people living in such a confined corner, it can be a health and safety issue. But again, it's up to the city. Now, even if the city didn't take action in that, the next question is, can the HOA do anything about it? What do you think?
Well, doesn't the city have occupancy limitation?
Yeah.
So if there's 2 bedrooms and there's 10 people and it does not exceed, isn't that a violation?
Exactly. The question is, okay, it's a violation, but the city's not doing anything about it. Can you, as the HOA, do something about it? As either the planned community or the condo? Can you?
Depends on your documents.
Yeah. Take a look at the back end in the miscellaneous sections of the CC&Rs. Oftentimes it will say any violation of federal, state, or local law shall be deemed a violation of these CC&Rs. And in that situation, absolutely. We just had a mediation with a great mediator. He's retired off the bench now, Judge Aceto. He's handled hundreds and hundreds of these HOA matters. And the community, our argument was they're violating all of these code violations. And their argument, the homeowner's argument was, well, that's up to the city to enforce, and the city's not enforcing it. And it admittedly wasn't in court, in trial. We didn't have a ruling from a judge's perspective, but he's a mediator. He's a well-respected judge, and he looked right in their eyes and said, look, these CC&Rs incorporate all these requirements, and I find that this is a violation of city code, so I don't care. Bottom line is the association can enforce this against you. There was all sorts of problems, noise violations, and they had all of this backed up. One thing you need to be careful about is that you don't just go off of one neighbor's argument, because that might be he said, she said. I always say, if you've got a noise violation or a nuisance complaint, it can be neighbor to neighbor, but if you have the community to start complaining about it, or you see actual tangible evidence of the violation, then okay, we can look at it a little bit more. Especially when there's 8, 9, 10 people living in that place. You're gonna have a lot of people complaining about it, especially in close quarters like a condo. All right. Let's talk about this case. Have any of you ever heard of this case, Westwood Homeowners Association versus TENOC? This is one of the first cases dealing with care facilities. And this is, I'm gonna designate the rest of the class today to care facilities, because group homes in my mind are a little easier to enforce, because there's no Fair Housing Act restrictions on you. When it comes to care facilities, you have to be very, very careful what you do in this scenario. Why? because oftentimes people are disabled, and there may be Fair Housing Act implications here. There very likely are not going to be Americans with Disabilities Act violations. Why? Because it's a private community association. But the Fair Housing Act is important to keep in mind. Interestingly enough, this case, what year was this? It was from 1987. And they tried, so this was a Court of Appeals decision that created case law, and the losing party tried to get the Supreme Court to look into it, but they ended up denying review. They granted it originally in 1987, and they denied the review in 1989. But this is case law now. And what this case was, is the association, Westwood Homeowners Association, didn't like the fact that TENOS were operating a care facility. Not a group home, but a care facility. What's the difference between the two again? What's a care facility? There's two elements there. One is care, and two is supervision. Has to be both, okay? And you have to have a license to have that. So they were operating a care facility out of their house for the mentally disabled. These are the facts. 6 or fewer developmentally disabled children and young adults lived in the home with an employee who provided them with parental care. All right? So we know that the elements are there now for a care facility. The association's argument back in 1987 was, hey, the TENOS are making money off of this. So it's a business. And our CC&Rs have a business prohibition. You cannot operate a business in your home if it doesn't pass the sight, sound, smell test. Okay? And the TENOS argued, yeah, we know this is a violation of the CC&R provision, but that CC&R provision can't be enforced because it's void as a matter of public policy. So that's the argument that this court had to face and decide was, okay, you have a care facility with disabled individuals. They're clearly violating the CC&Rs, but are we going to say we're not going to enforce this kind of provision for public policy reasons? What did the court say? You guys know?
Sure, they decide.
What do you think?
Public policy, I'm sure.
Yeah, they did. That's why we got the case right
Yeah.
here, right? So I'm going to read part of it. They went on for about 6 pages, 2 columns worth of analysis, analyzing different states' rulings, analyzing the statutes. They even cited Chief Justice Marshall from the U.S. Supreme Court. Chief Justice Marshall said this in 1985. Quote, as Justice Marshall recently explained, excluding group homes deprives the retarded of much of what makes for human freedom and fulfillment, the ability to form bonds and take part in the life of a community. So they went on to say this is the deinstitutionalization of the mentally handicapped, right? Or just the handicap period. So in conclusion, the court held this. We hold that the public policy contained in the applicable statutes extends beyond zoning to prohibit private covenants from impeding the reasonable establishment of these residential facilities in residential neighborhoods. So the key word here is from impeding or the reasonable establishment. Okay, so now here's the next question. If you have somebody operating a care facility and they do not have a license, can you do anything about that?
Report it to the state, correct?
You can report it to the state, but how many of you have reported things to the state? There's one example here where the state did do something about it, but it took a very long time. Meanwhile, you have all these people threatening to sue the association because one of the residents there is bullying kids at the basketball court, or 3 of the kids are out there burglarizing the neighborhood. Can you wait long enough for the state to do its investigation?
Can't you seek an injunction then?
Good question. So does this case prohibit an association from getting an injunction? No? I would agree with you. In most scenarios, there are some exceptions, but in most scenarios, when there's a health and safety issue at play, it's very easy to get an injunction. We do it all the time. We can even get a temporary restraining overnight order. I can go down to the courthouse this afternoon at 1 o'clock, and I can get a judge to sign off on a temporary restraining order. prohibiting these children from going out and burglarizing. As long as I've got proof, I can name the owner and make sure that that owner controls all the activity on their lot. And we've done that. And it's a very simple process so long as the evidence is clear. If the evidence is murky, obviously it gets a little more difficult. But we've done that. The next question though is, if somebody comes to you and you say, hey, you are operating can you prohibit them from having a care facility? Let's say they do have 6 disabled individuals that live in that home. Can you prohibit that? If they don't have a license, let me ask that question. If they do not have a license, can you prohibit it? So here's the scenario. This is, some attorneys say don't touch it with a 10-foot pole, right? The argument is you have neighbors complaining about all the noise and all the traffic and everything else. It clearly violates your business prohibition. It does not pass the sight, sound, smell test. You have all sorts of problems with the care facility. You ask them for a copy of their license. They refuse to give it to you. First of all, can you ask them for a copy of the license?
Say yes, because it would be public information, wouldn't it?
Who says, so I hear yes, who says no? Anyone say no, you cannot ask them for a copy of the license? Absolutely, you can ask them for a copy of the license. It's part of your due diligence. It's like you asking them to prove they're in compliance with state law. Because you know it's a care facility and you know you have to have a license to operate a care facility. If they don't provide you with a license, can you contact the Arizona Department of Health and Safety and ask them if there's a license for this? Absolutely. Have any of you contacted the Arizona Department of Health and Safety for a copy of the license? What'd they say?
What do you mean?
Did you contact like the department for a copy of the license for that care facility?
Mhm.
And did they give it to you?
I'm trying to think. I wanna say that you can, we have gotten them for some of them.
I don't know, I've never done it, I've never asked for a copy of the license before, so I don't know if the
I think
Department of
they'll
Health.
tell you if it's,
Yeah.
if they do have one.
Yeah,
If you give them the address or the owner, they'll tell you if they do have an active one.
perfect. So if you didn't hear that, step number 1 is to ask for a copy of the license. Step number 2 is contact the Department of Health and Safety to confirm that there's a valid license on hand. If they say there's a license, okay. If they say there's not a license, then all right. Let's assume that there's no license and they're just doing it. What do you do now? I would notify the authorities, but remember the authorities aren't going to be. They may or may not act on it very quickly. But you still have to do something because you got a lot of homeowners that are up in arms about this. So
report the issue to the state for them not operating with a license, but then still address the other issues at hand, just like you would any other owner.
yeah, exactly.
Violation.
So you have 2
Yeah.
different steps.
Are they protected by the Fair Housing Act right now? Let's say when you ask them for a copy of the license, they know they don't have one, but they say we want an accommodation of the Fair Housing Act because these are disabled individuals. Do you have to give them an accommodation?
Depends.
Yeah, what type of accommodation then? What?
Just an accommodation to allow them to
Oh.
care for the disabled in their home. Or let's change it up a little bit, to care for the troubled youth. So it's more like a halfway house now, not disabled, because disabled children don't usually go out and pick fights in the neighborhood. Most of the time we see this as a rehabilitation home with troubled youth, right? Or a sober living facility, something like that. So you say, hey, we want a copy of the license to confirm that you're authorized by the state to operate this care facility. And they say, well, we're not gonna give it to you, but we request an accommodation under the Fair Housing Act. Do you have to give them an accommodation? What's the key word in the Fair Housing Act? And it's confirmed by the Tenoff case.
Just to be the reasonable accommodation.
Reasonable accommodation. Is it reasonable to grant an accommodation that's illegal?
No.
No. If they don't have a license is it illegal for them to be operating the care facility?
Yeah.
Absolutely. So do you have to give them an accommodation for to do something that's illegal? No. This case says, we're not gonna enforce the private covenants, when it comes to, quote, reasonable establishments of these residential facilities. It's not reasonably established if they're not complying with Arizona law. It's unreasonable. So that's why you have to understand that when you're dealing with a care facility, it's kind of tricky, yes. But to summarize it, you can certainly get a copy of the license to confirm they're not acting illegally. If they refuse to give it to you, and I would typically send a follow-up letter saying, hey, look, okay, if you don't give us a copy of the license within the next 10 days or so, we're gonna assume you don't have one. And then meanwhile, I'm gonna try to confirm with the state that there is no license. The state may or may not be responsive to us, but at least I've got that letter out there to show that I'm on good grounds. And if the repeat behavior continues, we go out and get our injunction, and we don't have to worry about the Fair Housing Act being violated, because we've given them every opportunity. And again, if they respond to us and say you can't do anything about this because we're protected by the FHA, if they present a license to you, an actual license, then you get the local authorities involved on that end. But that doesn't prohibit you from getting an injunction against the bad behavior. If you've got kids out there that are beating other kids up or burglarizing, you just can't sit on your, you just don't need to sit on, you don't have to sit on your thumbs and not do anything about it. You can go get injunctions against that owner, even if they have the proper licenses, because the Fair Housing Act carves out an exception for health and safety. I know this isn't the yeah.
Why wouldn't the state respond to that? Because it would seem to be, that'd be fairly,
In that scenario,
I mean, operating a facility and treat handicapped people without a license seems to be pretty serious.
Sure. Let me take a step back. About 9-10 months ago, we had a situation where kids in a halfway house were picking fights at the community's basketball court. And one of them, we believe, was burglarizing the community. And so we had the members, there were several concerned neighbors, obviously. They gathered evidence, they had videotape footage. This individual that was operating the care facility did have a license. We notified the state, and their license was revoked within 4 months. But that's the fastest I've ever seen it revoked. But that doesn't mean you can't do things on your own. Because that's a repeat theme with Greg in our interview. You have the things that the government can do, and you have things that the quasi-government, the HOA, can do. So sometimes they overlap.
Seem to be two different scenarios. One is that they have to look into the facts of the case and all that kind of stuff, and the other one is they don't have a license and they're operating. It's a simple cease and desist, isn't it?
Yeah, well, in that scenario, they got a letter from the association. Behavior didn't stop, so they got a letter from me. The behavior didn't stop. They got a second letter from me. The behavior still didn't stop, and it actually increased for whatever reason. And at that point, we got a temporary restraining order against the homeowner to curtail all of the behavior. Meanwhile, 3.5 months later, the state yanks the license.
But they had a license. But if they didn't have a license?
If they didn't have a license, you can get that prohibited, I believe. Even if the 10-off case would allow that.
Yeah.
Because this only protects, quote, reasonable
Right.
establishments. And these aren't reasonably established. They're illegal. So in that scenario, in a situation, because the example I'm explaining had a license, we had to go through it with the state
Right.
on one end to yank the license later, but on the other end, get the behavior stopped immediately through a temporary restraining order. If they didn't have a license, I could have done both immediately. And I could have thrown in the business prohibition provision too.
Right.
And I could have argued that 10-off supports that because it's not reasonable, it's illegal. So, that's how we handled that scenario, yeah. That answer your question?
Yep.
Great. Any other questions on that? Okay. A few horror stories that we've seen. Have you ever heard the oogling horror story? This is the peeping Tom one. So I asked Greg, I said, hey, do you have any horror stories? He said, yeah, I've got one where, there's two actually, these are the three. He mentioned this briefly, but I'm not even gonna get into this one, it's too gross. Oogling, so he said there was a elderly care facility in a planned community, and one of the people that lived and getting care was kind of a pervert. And a peeping Tom, I guess, and he would go around with his binoculars and he would spy on girls in both park, and then he would spy on them in their houses, and just really creepy guy. So the manager or the neighbor, one of the two, I can't remember what he said, but anyways, they made a complaint to Scottsdale, and Scottsdale investigated, and they just turned it over to PD. Code compliance is gonna deal with that. But that's an example. And then the smoke one was the one I shared with you before. We had 10 people living, it was a group home, living in the condo, and they were constantly smoking. The smoke was going, it was on an shared HVAC system, so the smoke was constantly going throughout that building. It was a pain. And in that scenario, while the city, it was zoned multifamily, the city said they wouldn't do anything about it, but they turned it off to the fire department. And the he said specifically the condo could have done anything they wanted to in that scenario. That's the perfect example of when you have a group home where even if the city's not gonna do anything about it, you can do stuff about that when it's impacting the quiet enjoyment of the other members. The suicide was in a halfway house. An older individual was walking down, I think he was 18 or 19. He just committed suicide on the street of the association, and everyone got a chance to see that. It's pretty gross, pretty sad. But things happen, whether suicides happen, smoke happens, oogling happens, doesn't matter if you're a group home or not, care facility or not, it happens. The bigger question is, can you do something about it, and should you do something about it? So the whole point of this class was for everyone to walk out of here knowing that don't let the fact that it's a group home or a care facility scare you away and just make you throw your hands up in the air. That can get us into trouble. If it's a group home, most requirements, again, require group homes to be in zone multifamily. You gotta check each city's zoning ordinances, but in most cities, if a group home is in a single family community or zone single family, it's a violation of the statute or the zoning ordinance. The second part is the care facilities. If it provides care and supervision, it can be protected. They have to have a license though. If they don't have a license, you can throw in your business prohibitions. If they do have a license, you can still get crazy behavior stopped. And you can get their license pulled if the behavior is crazy enough. So that's the important point. The last point I was gonna raise in this stuff is when it comes to the fair housing, some of these operators, home operators, they feel like they're just protected from the under the Fair Housing Act and can do whatever they want if they've got a license. And they may file a Fair Housing Act complaint against the association. That's why a lot of attorneys, I think, are like, be very, very careful what you're doing, because they're worried that they'll retaliate with a Fair Housing Act complaint. And this, as you know, have you all been through a Fair Housing Act complaint? They're pretty easy to do. Hopefully now, because they're on the rise, you've got insurance protecting it. But bottom line is you can't let the fear of having a Fair Housing Act complaint filed against you stop you from enforcement. If it's, get your attorney's opinion, whether it's a Fair Housing Act violation or not. If it is a Fair Housing Act issue, back off for sure. You don't want that. But if there's no Fair Housing Act issue, and they're just gonna file the complaint, it's gonna get dismissed. 99 times out of 100, those things are dismissed. So, anyways, that's the class. Any other questions? Yeah.
Can't believe you called them easy. I went on the Department of Health Services website, and you can download the whole list of residential care facilities.
Oh, really? Cool.
And you can file online complaints.
So just in case you didn't hear that, Regis went on to the department's website and you can download the entire list of care facilities. So, do you have the URL up top that I can say?
For this.
Yeah. Where did you go to get that list?
It's azdhs.gov.
azdhs.gov.
This one is /documents / I can't.
When you went to the main
Licensing.
home page,
Oh.
how did you navigate there? So you started with the home page.
I went to licensing,
So you went, then there's a licensing link, you clicked on that, and then,
residential facilities licensing.
Then
So if you go
residential-
down, I went to I am a consumer or something, and then I went to licensing, and then there's a residential license, facilities licensing menu.
oh, perfect.
And
So-
then you can actually download all the providers, or you can file a complaint.
Excellent, perfect, thank you. So yeah, you can pull them to confirm whether or not that individual in your neighborhood is operating a licensed or an unlicensed care facility. Excellent, thanks. Are there any other questions? Perfect.